Good evening, dear friends, dear colleagues. First of all, thank you all very much for your presence tonight for this 2022 Gaillard Lecture. As I hope you will all agree, with the premature and tragic passing of Professor Gaillard, a bit more than 18 months ago now, the arbitration world has lost a great mind. Professor Gaillard was a true visionary who has left a very important footprint on international arbitration law. Quite simply, the contributions that he made over his career as a revered and admired academic, practitioner, prolific author, teacher, and mentor played a significant role in shaping international arbitration into what it is today. This is why, in seeking to honor and celebrate his legacy, my partners and myself have thought that an annual lecture would be a fitting tribute. And you may recall that we launched the series last year at the event organized at the Petit Palais in Emmanuel's honor, starting with Justice Dominique Achère. Today, we are truly privileged to have the Right Honorable, the Lord Leonard Hofmann, deliver the 2022 Gaillard Lecture, and where else to organize this event than the Cercle Interallié, Emmanuel's Club, and the location he used time and again to organize memorable IAI and Arbitration Academy conferences and lectures, as many of you will recall. Lord Hofmann is, among other things, a former Justice of the House of Lords, an accomplished barrister and a leading arbitrator. He was described by Lord Sumption as, and I quote, probably the most creative legal mind to sit on the Judicial Committee of the House of Lords in the last half-century of its existence. Nothing less than that. Born in South Africa and raised during the war, Lord Hofmann traveled as a Rhodes Scholar to Oxford in 1954 to undertake the BA in jurisprudence and a Bachelor of Civil Law, graduating as Vinerian Scholar for his top performance in his cohort. He then worked as a tutor at Oxford and developed a successful career at the bar, being appointed Queen's Counsel in 1977. Appointed to the High Court in 1985, he was rapidly elevated to the Court of Appeal in 1992, and then to the House of Lords in 1995. He sat in the House of Lords until 2009, retiring shortly before the Judicial Committee's responsibilities were transferred to the UK Supreme Court. Lord Hofmann is widely recognized as the Judicial Committee's intellectual leader during his tenure. He is renowned for his mastery of a remarkable variety of legal subject matter, making seminal contributions to the law of contract, tort, intellectual property, evidence, and human rights, among other things. His judgments are known for their lucid written style and for their ability to cut through unnecessary and archaic nuance, bringing great clarity to the common law. Lord Hofmann has practiced arbitration while at the bar, and he made major contributions to its developments while on the bench through landmark decisions such as the Fiona Trust. Lord Hofmann returned to arbitration upon retirement from the House of Lords. As those who have had the privilege of appearing before him will know, Lord Hofmann is an extremely sharp arbitrator with a rigorous command of the cases before him. As my partner Mohamed Shelbaya will describe in a short moment, it was on one such case that Lord Hofmann and Professor Gaillard first met. And before I pass the baton to Mohamed, I would like to thank you again for your presence and to warmly thank Lord Hofmann for his presence tonight and for having come all the way from London for this event. Thank you very much, Lord Hofmann. Thank you, Mohamed.
Well, in Iolante, Gilbert and Sullivan ironically imagined a speech by the Lord Chancellor in which he says, "The law is the true embodiment of everything that is excellent. It has no kind of fault or flaw, and I, my lords, embody the law." Now, in real life, the law has many faults and many flaws. But in all seriousness, and all joking aside, I cannot think of two people who, to me, embody the efficacy of law more than the late Professor Gaillard and Lord Hofmann. Their respective contributions to the law seem to us mere mortals permeated by the principle that the measure of a good rule or a good theory is its ability to achieve the practical result that most closely reflect life's reality. Now, from Lord Hoffman's brilliant reformulation of the law on economic torts in OBG versus Allen, his realistic approach to construction in Fiona Trust, or his presumption regarding foreseeable losses in Achilles, to Emmanuel's creation of the negative effect of arbitration agreements, his test for identifying corruption, or his approach to dealing with anti-arbitration injunctions, these are all rules and approaches that seem designed to ensure that the test of a rule or a legal process in question achieves the practical result for which it was designed. Now, I had the privilege of working on many cases with both Emmanuel and Lord Hoffman, in which they were involved in different capacities. Now, one such occasion was the Dow Chemical versus PIC case, in which Emmanuel and I appeared as counsel for Dow Chemical, and Lord Hoffman sat as an arbitrator. Now, the tribunal in that case issued an exceptional award in which it went out of its way to specifically refer to Emmanuel's cross-examination as, and I quote, particularly effective. Now, of all the praise that Emmanuel got throughout his career, and he received much, this one was particularly dear to his heart. Now, not only because of its source, although that certainly was part of it, but also because of its subject matter, because it's related to the efficacy of his advocacy skills, a value that was very important to him. Now, years later, Emmanuel again and I were again to appear as counsel in legal proceedings, in which this time Lord Hoffman appeared as an expert on English law. Now, his opinion, some 10 pages long, eclipsed the hundreds of pages written by counsel for both parties on the issue in question by its clarity and its effectiveness. Now, opposing counsel subsequently had the unenviable task of having to attempt to cross-examine Lord Hoffman. And ever since that case, the joke that Emmanuel and I would always repeat is that redirect examinations are almost always futile unless the witness is Lord Hoffman. Now, in view of that, it is most befitting that one of the first Gaillard lectures to be delivered by none other than Lord Hoffman, and on no other topic than the efficacy of law. And with that, I ask Lord Hoffman to take the floor. Thank you very much.
Before I say anything more, I have an apology and a question. The apology is that I'm going to speak entirely in English. Having been brought up in South Africa, my French is vestigial. The question is, can I be heard? Can everybody hear what I'm saying? Good. Well, now, the first time I met Emmanuel Gaillard was in 2009 when he appeared as counsel for the claimant in an arbitration. It was my very first experience of sitting as an arbitrator after I'd retired as a judge. It took place in the offices of Sherman and Sterling in London. And I remember I bought a new pair of shoes for the occasion, as if I was going to a new school. Perhaps I thought my feet would be visible under the table when they would not have been in my former life sitting behind a desk in court. But Emmanuel's advocacy was a breath of fresh air. He was clear, often amusing, short and to the point. And then I had the good fortune to encounter him as counsel in one or two later cases, to attend a couple of his lectures, and of course, to talk to him at those gatherings of arbitrators in distant places, which he once analyzed as part of the sociology of arbitration. The sociology lecture, which was in Freshfields in London, and others of a philosophical nature, presented Emmanuel in a rather different light not so much the practical lawyer skillfully presenting his case to the tribunal, as the public intellectual in the French style. But he did both brilliantly, and his death is a great loss. Now, Emmanuel had strong views about the legal system or systems which gave arbitration its validity as a means of resolving international commercial disputes. Now, although an arbitration has to take place somewhere, that place is, as you all know, not necessarily its legal seat. Parties are free to designate a seat and then to hold the arbitration elsewhere. But the fact that the seat might be in a place where none of the arbitrators or parties set foot during the arbitration made it difficult to argue that its validity is derived from the territorial sovereign of that place. By specifying a seat, the parties choose a system of law under which they want their arbitration to be conducted, a procedure, but Emmanuel said, and I think correctly, that system applies by virtue of that choice and not by virtue of the sovereign authority of the country which is designated as the seat. Emmanuel also rejected the notion that arbitration derived its legitimacy from the collectivity of sovereign states that have agreed to enforce awards in accordance with the New York Convention. That, in his view, was an incoherent argument. Some might be obliged under the Convention to enforce the award and others not, perhaps because of legitimate different views of what public policy required. One can't identify any common requirement that would ensure enforcement in all states. So his conclusion was that arbitration derived its validity simply from the consent of international parties to go to arbitration. Its validity is recognized by, but not created, by the courts of the countries which provide assistance of various kinds and which enforce the award. If that seems to have echoes of the Nicene Creed, it's none the worse for that. Now, this emphasis upon the autonomous nature of the agreement to arbitrate, based entirely upon the agreement of the parties, led Emmanuel to deplore the invention of the courts at any stage in the arbitration process. He praised the policy of the French courts, which he said was to give such assistance as was needed to get the arbitration on its feet, for example, by appointing an arbitrator if a recalcitrant party refused to do so. But thereafter, to abstain from any form of intervention until called upon to enforce or set aside the award. It was for the arbitrators in the first instance to decide, and that not only could the arbitrators decide whether they had jurisdiction, but no one else could try to do so first. Now, not all countries, however, are willing to defer the consideration of a question of jurisdiction until the arbitrators have issued their award. To say, as according to Voltaire, the British general said to the French guards at the Battle of Fontenoy, "Gentlemen of the guard, fire first." They sometimes think it would be a waste of time and money for the arbitration to proceed if, in their opinion, the dispute doesn't fall within the terms of the agreement to arbitrate. So this means the courts have to decide, if that's their attitude, have to decide what law governs the arbitration agreement, what it means, and its effect according to its governing law. Now, these questions are sometimes difficult, as questions of the interpretation of language often are. In most systems, the arbitration clause is regarded as being a separate contract, not necessarily governed by the same law as the other provisions. It is, however, extremely rare for the arbitration clause in itself to refer to any system of law. And as you must yourself have had experience, quite often the main contract even contains no express choice of law at all. So the court has to try to discover what the parties are likely to have intended about these matters, or at least that's what it says. In the case of the main contract, if there's no express choice of what law to apply to it, and no provisions which enable the court to say that it must have been such and such a system of law, then they are guided by the Rome Convention, which is to say they should choose the system of law with which the contract is most closely connected. Rome 1 doesn't apply to arbitrations, but the ordinary English conflicts of law say more or less the same thing, and so the governing law of an arbitration clause will be chosen in the same way. Now, all of this requires a somewhat complicated balancing of factors. Reading the meager tea leaves in the language of the parties and the surrounding circumstances to try to discover what intention should be attributed to them. Well, it's a fine expression of the principle of the autonomy of the intention expressed by the parties, but it's a little impractical sometimes because it can lead to additional delay and costs while these questions are decided by courts, sometimes at more than one level in the judicial hierarchy. Well, what's the answer to this problem? One answer is, of course, the French solution of letting the arbitration run its course and letting the court intervene, and if there was no jurisdiction, afterwards, and set aside the award. But that creates the possibility that time and cost will have been taken up in having an arbitration, which in the end turned out to have been completely wasted because the court said there was no jurisdiction and there was nothing to enforce. Another rule is to have a fixed rule which will apply unless the parties have expressly chosen something else. Now, that respects the principle of party autonomy. The parties are free to choose something else if they actually think that that would be better, and it does create certainty. And that's why what the English courts have done with the principle that the arbitration agreement as a separate agreement can survive the termination or invalidity of the main contract. Emmanuel's view was that the English courts were rather late in adopting the principle that the arbitration clause was a separate agreement. He thought not until the decisions of the Court of Appeal in 1993 and the enactment of Section 7 of the Arbitration Act of 1996, which says so expressly, that not until then did it become part of English law. But that's not altogether true. For at least 80 years, English law has been willing to treat an arbitration clause as separable. But separable does not necessarily mean separated. And it was a matter for the parties to decide whether they wanted the arbitration clause to be treated as separate from the main contract. And to discover the intention of the parties, the English courts, for many years, undertook a minute examination of the language that the parties had used. Did they say it should apply to disputes arising from the contract, or under the contract, or out of the contract? And sometimes they said this meant it was separable, and sometimes they said no, it didn't. Well, in the Fiona Trust case in 2007, the Court of Appeal said this was absurd. And Lord Justice Longmore said ordinary businessmen would be surprised at the nice distinctions drawn in the cases, and the time taken up by argument in debating whether a particular case falls within one set of words or another very similar set of words. If businessmen go to the trouble of agreeing that their disputes be heard in the court of a particular country or by a tribunal of their choice, they don't expect, or at any rate when they're making the contract in the first place, they don't expect that time and expense will be taken in lengthy arguments about the nature of particular causes of action and whether any particular cause of action comes within the meaning of the particular phrase that they've chosen in their arbitration agreement. If any businessman did want to exclude disputes about the validity of the contract, it would be comparatively simple to say so. And that approach was upheld by the House of Lords, which stated the law in the form of a presumption. They said the construction of an arbitration clause should start from the assumption that the parties, as rational businessmen, are likely to have intended any dispute arising out of the relationship into which they've entered, or purported to enter, to be decided by the same tribunal. The clause should be construed in accordance with this presumption unless the language makes it clear that certain questions were intended to be excluded. Now, this is an example of what the Nobel Prize-winning behavioral psychologist Richard Thaler and the law professor Cass Sunstein called nudge theory in their well-known successful book 1908 called Nudge, Improving Decisions About Health, Wealth and Happiness. You, the judge or the legislator, you allow people to choose as they please, but you present the choice in a way which makes it more likely that they will choose what you regard as, on the whole, the best choice. You give them a nudge in that direction. Sunstein and Thaler called it libertarian paternalism. If the parties want to restrict the scope of the arbitration clause, we, the courts, will respect their autonomy. But we structure the rule in such a way as to make it more likely that they will be treated as having chosen what we regard as the best option, namely that the separability of the arbitration clause is given the widest possible scope. If they don't say anything plainly inconsistent with such a construction, as normally they don't, then that's what they'll get. Now, it was this presumption which then enabled the courts to deal with what Emmanuel called the dirty tricks, or at least one of them, played by litigants who wished to avoid arbitration or set aside unfavorable awards, or simply to delay the proceedings, namely the argument that the arbitration clause isn't wide enough to cover the dispute. And the title of this talk, The Efficacy of the Law, is because I'm concerned with how the decisions of the parties to have disputes decided by arbitration can be made effective without the delay and cost of proceedings along the way. But these battles to make arbitration effective have to be fought over and over again. And in the English courts, a year or two ago, in a case called Anchor and Chubb Insurance, a very similar battle was lost. And the question it raised was, What law governs the agreement to arbitrate? Was it the law of the seat that their parties have chosen, or was it the law which governs, one way or another, the rest of the agreement? Now, the facts of the Enka-Chubb case were not particularly complicated. Enka is a Turkish construction company. It was engaged as a subcontractor to build part of a power plant in Russia. The contract didn't have any choice of law, but it contained a number of references to provisions of Russian law down in the small print, and it certainly had to be performed entirely in Russia. So Russia was certainly the country and system of law with which it had the closest connection. But the disputes clause provided for arbitration in London. Now, the owners were insured by the Chubb Insurance Company, and in February 16, there was a big fire, and Chubb, the insurers, paid out the owners, and in paying out the owners, they became entitled to any rights the owners might have against people who, say, negligently started the fire. And so in May 19, Chubb sued Enka and some others in the commercial court in Moscow. Well, Enka said, "You've agreed to go to arbitration," and they applied in the Moscow court for a stay pursuant to the Russian equivalent of Article 2.3 of the New York Convention. They also said on the merits, well, we weren't responsible for the fire. It had absolutely nothing to do with us. And they commenced arbitration proceedings in London, and as it happens, appointed me as the arbitrator. They applied also to the London Commercial Court for an anti-suit injunction to restrain Chubb from going on with the proceedings in the Moscow court. In December 19, the commercial judge refused to grant an anti-suit injunction. He said there was a dispute about whether the claim they were making came within the arbitration clause, a question of Russian law and construction of the claim. And he said the appropriate court to decide the dispute was in Moscow. And Enka appealed to the English Court of Appeal. Enka's view was that the arbitration clause was governed by the law of the seat, which was English. Before the appeal was heard, there were further proceedings in Moscow, which I'll come back to in a moment. But just let's consider the Russian judge's decision that the arbitration clause, like the main contract, was governed by Russian law. The case for having the main contract governed by Russian law was a strong one. It was hard to see what other law could have been the appropriate law for the main contract. But it doesn't follow that the arbitration clause was governed by Russian law. Now, it seems to me that there's no reason why an arbitration clause should not be regarded as separable for the purpose of deciding which law governs it, just as it is for the purpose of deciding what disputes it discovers. The two are very closely connected. So the interpretation and effect of the arbitration clause doesn't necessarily have to be in accordance with the law governing the main agreement. And if that's right, then the question is, how does one decide between, is it the law of the main contract or is it the law of the seat? In my view, the most convenient choice, the best choice they could make, would be that it's the law of the seat, because on any view, the arbitrators are going to apply the procedures in the law in the seat, what's sometimes called the curial law. And the boundary between those procedural laws and the question of what the arbitration clause means is not a very clear one. I mean, what the arbitration clause means can affect the way in which the arbitration is conducted. So, following the judge in the nudge technique used in the Fiona case, the court might have declared a presumption that the arbitration clause is governed by the law of the seat, but leave it free to the parties to say expressly, no, we want it governed by the law of the main contract or any other law that they chose. Now, if for example, if you agree to arbitrate in London in accordance with the rules of the London Chamber of International Arbitration, you get a very firm nudge in the direction of the law of the seat. Rule 16.4 of the LCIA rules says the law applicable to the arbitration agreement and the arbitration shall be the law applicable at the seat of the arbitration unless and to the extent that the parties have agreed in writing on the application of other laws or rules of law. Same is true if you arbitrate in Scotland. Section 6 of the Arbitration Scotland Act 2010 says if the parties have agreed a Scottish seat and the arbitration agreement doesn't specify which law it is to govern it, then unless the parties otherwise agree, the arbitration agreement is governed by Scots law. And the Swedish Arbitration Act is, as I understand it, to the same effect, and no doubt there are similar rules in other countries that I've not researched. Now, it's true that the LCIA nudge has been incorporated into the contract, incorporated by reference. If you say we want it done by the LCIA rules, that's one of them. And the Scots and the Swedish provisions are statutory. But there's no reason why the courts in the Anchor case shouldn't have invented such a presumption, just as they did in the Fiona Trust case. Such a clear-cut rule is particularly necessary when the question is whether the court should grant an anti-suit injunction. It's an interlocutory remedy, which is often a matter of urgency. In the West Tankers case, when the question was whether an anti-suit injunction could be granted against proceedings in the courts of another member state, and we were given a raspberry and told that we couldn't do it. But the House of Lords thought it went without saying that the Court of the Seat would decide whether the arbitration clause was binding. Well, in March 2020, and while the Court of Appeal to the Court of Appeal was pending, the Commercial Court in Moscow gave its decision. It refused to stay under the New York Convention, but it dismissed Chubb's claim on the merits. Neither side was satisfied with that result, and both of them appealed. And that was the position when the London Court of Appeal gave its decision the following month. And it did exactly what I've suggested was necessary to create certainty in this part of the law. It created a presumption, similar to that for the construction of the agreement in Fiona Trust, that the arbitration agreement was to be governed by the law of the seat. It respected the autonomy of the parties. If they expressly agreed it should be something else or some other law, then, as in the case of the LCIA rules or the Scottish law, that would be given effect. It even allowed that without express provision, the terms of the agreement might make it clear that the parties expected the arbitration clause to be governed by the same law as the main agreement. But it created the nudge, and the Court of Appeal therefore held that the agreement to arbitrate in London was governed by English law, and it granted an anti-suit injunction. Then there was an appeal to the Supreme Court. The Supreme Court divided 3-2. The majority judgment runs to 49 pages of the law report, in which they agreed that the arbitration clause was governed by English law, but, regrettably, not for the same reasons. I'll come back to the reasons in a moment. The two minority judges made do with 38 pages between them, and they held that the arbitration clause was governed by Russian law. They wouldn't have sent the case back to Moscow, as the judge of first instance would have done, but they would have sent it back to the English Commercial Court to decide on the basis of expert evidence whether, under Russian law, the dispute did or didn't fall within the terms of the agreement. And if the court thought it did, then they could grant an anti-suit injunction. Well, if the facts were not particularly complicated, the judges of the Supreme Court, both the majority and the minority, their judgments certainly were. The majority said that if the contract, the whole contract, the main contract, contained an express choice of law or a necessarily implied choice of law, that if you could get that from the terms of the main contract, that law would also apply to the arbitration agreement. They rejected the argument that the arbitration agreement could, for this purpose, be treated as separate. That principle, they said, applied only to enable the arbitration agreement to survive invalidity or termination. In principle, they said, their rule, that you'll have the same rule to the whole contract, provided certainty, which I suppose it did, and coherence, and avoided what they regarded as the artificiality of the separability principle, which they said was much better known to arbitration lawyers than to commercial parties. The commercial parties, they said, would reasonably expect a choice of law to apply to the whole of their contract. On the other hand, they were willing to make an exception if the arbitration clause under the law of the main contract would be unenforceable. You have that sometimes. In the case in the Court of Appeal, the question was whether the main contract was governed by Brazilian law. There was a seat in London. And the question there, apparently, according to Brazilian law, if you have an arbitration agreement in your contract, you still have to agree to arbitrate again after the dispute is broken out. So if you don't feel like arbitrating, you just say, well, I don't consent, and that's that. So in that case, they said, well, yes, there to apply Brazilian law would, in effect, destroy the arbitration agreement, and they were willing to make an exception in such a case. Though, again, these are difficult boundaries, aren't they, to know what counts as destroying the arbitration agreement, what makes it just a bit more difficult to operate, and so on and so forth. However, they said if there was no express or implied choice of law in the main contract, and you had to find out what law to apply to the main contract by using the test of what system it has the closest connection with, then the principle of separability suddenly reappears. Russian law might be the law of which the main contract has the closest connection with, given its Russian subject matter. But they said the arbitration clause has its closest connection with the law of the seat, and therefore it's governed by English law. Now, there's, I must confess, a certain sort of rabbit out of a hat quality in this argument, and I'm not altogether surprised that the minority didn't agree with it. Well, now, all in all, that case leaves ample room for future litigation. For example, the boundary between saying that the choice of law can be implied from indications of a connection with Russian law in the contract, and saying that Russia is the country with whose system of law it has the closest connection, that boundary is not a very clear one. There are grey areas. In the Inca case, the minority thought that you could imply a choice of Russian law. And the majority disagreed, and they thought Russian law did apply, but only under the test of it being the closest connection. Now, normally, if both tests give you the same answer, it doesn't terribly matter which one you choose. But now, the way you decide which law applies to the main contract is critical to deciding what law governs the arbitration agreement. If you do it on the basis of implication, then it's the main contract law. And if you do it on the basis of closest connection, then it's the law of the seat. Well, there does seem to be absolutely no logic in a rule of that kind. Furthermore, everybody agrees there are other grey areas in distinguishing between the procedural and curial law for conducting an arbitration, say in England, and the question of what's the effect of the arbitration clause. To this, the majority offers, it seemed to me, a remarkable answer. The UK Arbitration Act 96 provides the parties may exclude any provision of the Act which is not stated to be mandatory. Well, that's what mandatory means. If it's not mandatory, then they needn't have it. It also says that if you say that something which is covered by a non-mandatory provision shall be governed by a foreign law, that counts as an exclusion, and you substitute the foreign law for what would otherwise have been the provision of the Act. And all this makes perfectly good sense if you can see that in respect of some aspect of the arbitration, the parties have said expressly that it's to be governed by the foreign law and not by the Arbitration Act. As long as it's not mandatory, they're free to do that. But what the majority in the Enker case decided was that if, according to their principle, the arbitration clause is governed by a foreign law, i.e., according to the principle that you apply the law of the main contract, then that counts as an exclusion of all the non-mandatory clauses in the Arbitration Act. And that includes, for example, Section 7, which is the clause which the section which states the principle of separability. So you can imagine a party from Ruritania who does not wish, as he agreed, to have decided in question in London the question of whether he obtained by bribery an agreement expressed to be governed by Ruritanian law. He will say to an English court, well, Ruritania is a country of simple people, and as the Supreme Court said, even of commercial people in England, they know nothing of the principle of separability. And if the agreement is voidable, the arbitration clause there goes with it, and the award is a nullity. Well, I understand that in other arbitration centres, and I look around the room, there's a certain quiet satisfaction at the Supreme Court's decision in the Enker case. It makes arbitration in London open to another of Emmanuel's dirty tricks, namely that under a foreign law, the agreement to arbitrate is subject to some onerous provision. Maybe the majority in Enker could have dealt with such a plea by their exceptions for foreign laws that would make the arbitration agreement inoperable. But there's plenty of scope there for litigation. I mean, after all, we had arbitrations before Fiona Trust, and nobody said they were inoperable. They just sometimes didn't operate very well. Well, what's to be done? Perhaps parties to contracts which provide for arbitration in London, but with a main contract governed by the law of another country, should be advised to use the LCIA. That would certainly produce the necessary nudge. Alternatively, the English Law Commission is at the moment considering whether improvements could be made to the 96 Act, and they could advise that we align our law with the law of Scotland. Why not? The Scots are still part of the United Kingdom. And if Emmanuel were around, I dare say he would have found an imaginative solution. But another reason for mourning that he's not.
Thank you very much to Lord Hoffman. Unless there are, well, perhaps we see if there are a couple of questions before we move on to the cocktail, which will be right here to the right. A mic would be so good.
Thank you. Just in the case that we were discussing, the place of arbitration was actually in the clause. Do you think the situation should... So, in the example, the case we were talking about, the place of arbitration was determined in the clause itself, and then the court goes on to talk about what the parties may have wanted and looking at the will of the parties. What about a situation where the place is not determined in the clause, but is determined by an institution, which is not necessarily the will of the parties, and the institution may then choose a place which is completely different to what the parties could have expected in order to maintain neutrality? What do you think the court may decide in those where we're not looking at a will?
Yes.
Thank you.
I mean, that's a very interesting point, I would say, which I would look forward to seeing what the court had to say about that. My own view, just sort of off the cuff, is that if you allow an institution to determine the place of arbitration, you take its law with it. And it may be that it's not something which was expressly chosen by the party, but it's something which they allowed the institution to decide for them. So I would treat that in the same way and still apply what was the law of the sea, even though the parties had not themselves chosen it. But that, I mean, I give you that to you as a sort of immediate answer, and I dare say other people might be able to produce arguments to the contrary.
Should we perhaps move to the cocktail then? Thank you very much, Lord Hoffman.